Very good afternoon, everyone. Welcome to today's uLaw webinar. And the topic for today's webinar, or the title, is Law Office Matter Management. You can call it Legal Office Matter Management, but the actual official CPD title is Law Office Matter Management. And today's webinar has been accredited for 1 hour of professionalism CPD credits in the provinces of Ontario, New Brunswick, and British Columbia. We are working very closely with other provinces, and we hope, starting with Alberta and some other provinces to come follow suit, we would be able to expand the CPD accreditation in the coming weeks and months. So thank you for your patience, and I want to make this as interactive as possible, though many times these webinars almost ends up being a monologue. I encourage you to use the chat window to ask either myself or the support staff any questions that you may have. So I reiterate, 1 hour of professionalism CPD credits about law office matter management. Okay? Like every other uLaw webinar, today's webinar has a specific agenda. The agenda really talks about matter management and the different subsections and the responsibilities, the tasks, and the resulting documents and reports that reflect how well your legal firm or your law firm has managed those matters. We're going to talk about the creation of these matters and the importance of that, the prerequisites, the life cycle, and the different statuses that a matter can potentially go through, and some examples of that. We'll look at the compliance documents. Not only are there compliance for the financial aspects of your business, there are also compliance with regards to how well you manage your matters and all of the documents and the prerequisites that go along with creating and managing those matters. Handling retainers, which is a very important aspect, whether a retainer letter or an engagement letter, if you were to call it, the importance of many very practical documents such as receipts, non-engagement letters, and how important that is as part of that matter cycle. Some of the Law Society's requirements about your intake of a matter, disbursements, which is something that we covered in great detail in our last week's webinar, and how that plays an important role within a matter. The concept of trust and general management when it comes to a matter. And one of the most important fundamental money-making steps, which is invoicing your client based on the work reflected in the matter and either doing trust transfers or accepting client payments. So a lot of action happens within this matter management section of your legal business. Whether you use a legal accounting software, practice management software, a paper-based software, we still believe there are certain important aspects and the essence of the matter management as regards to the expectation from the Law Society, as well as the expectation from a general operational efficiency. Those two important components can be well defined and combined and improvised within the matter management, I would say, portion of your overall legal business. We'll take a quick look at a prerequisite to the whole matter management component. So we're getting into the matter creation, but there's certainly a prerequisite to that. So a matter, as you probably know as well, is created in the context of a client or a prospective client or a ghost client. It doesn't have to be always the situation where you create it for a client and you're doing the work. It can so happen that a prospective ghost client, as they're termed in legal lingo, give you a call, give you some basic information, give you enough, you go with the leap of faith that they're going to retain you or engage you and give you a lot of information. I'm going to take my neighbor to court. I want to, fight this particular traffic ticket. whatever may be the situation. I want a separation or divorce. I'm purchasing a real estate property. There could be various reasons why someone gives your law firm a call and gives you as much as information as they feel prudent at that particular point in time. Now, if they come back and engage your law firm and pay for your services either as a retainer or sign an engagement letter as a way of acceptance, then of course they are a client. Within a stipulated period of time, if you feel that they have not reached out to you or conducted that piece of the business, then of course you as legal business would have to tag them or mark them as a ghost client, so that for law society purposes as well as for conflict check purposes, you have that information available. You send them a non-engagement letter clearly stating that, hey, we flirted with this idea of us working together. You gave me all this information, but since you've not engaged with this firm, which is kind of our policy, then of course I'm having to non-engage you, which means that my legal firm or this legal firm is no longer responsible to manage that legal problem that you have, because that gets you off the hook. That's kind of, of course, the worst case scenario. I'm sorry I've started out with that, but happens quite often. A prerequisite to this whole, yada, 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 is the client intake process. And that starts with that person either reaching out to you through your website, giving you a call, looking at your advertisement and reaching out through email, whatever initial point of contact may be. Now starts your clock and your responsibility to store all that information in an easy to retrieve system that you can be proud of, you can be easier to help manage it within your firm. Pieces of information such as detailed recording of that initial call or consultation. We're starting to see a lot of legal firms provide free consultation, or the first 15 minutes or 20 minutes or 1 hour, however you want to frame that marketing message, provide that initial consultation. And after that, each and every part of that conversation pertaining to a specific legal problem converts itself into a data component within a matter. So if they called you regarding a real estate purchase, that becomes potentially the title of the matter. If you charge, let's say, a set retainer to deal with certain types of areas of practice, for Wilson Estate, maybe you have a flat fee. For criminal, you may have kind of a time and material. For small claims, you may have flat fee. And for other businesses or areas of practice, rather, you may have your own retainer fee structure. That becomes a critical component as you discuss during the intake process. Because often, I'm sure you can relate to this, the client is going to ask you saying, all right, how much would it charge? How much would you charge me for this? How much would it cost me to engage your service, right? That becomes an important component of the matter under a retainer or engagement letter. As part of you clearly articulating the roles, responsibilities, and the policies that surround and govern that letter. Now, when you first intake that client, a very important step that the Law Society does talk to you about is ensuring that there are no conflicts in representing that individual, and hence conflict checking becomes a critical information. Now, why are we talking about all of this in matter management? As part of the matter compliance, it's important once you've done that intake or during the process, before you even start that matter, that you do this conflict check and make it simple on your legal business to have a valid proof by running the conflict check and filling out a document, hopefully, to stay in compliance, that tells your auditor that when you're being asked of it, you can tell them, this is the reason why I went ahead with creating a matter. So each and every aspect of that initial client conversation has the potential to be part of that matter data. And why is it important for you to consider matter management, and what is the whole concept of it? So in a legal business, again, beyond a point, I do understand that I'm kind of preaching to the choir. Many of the experienced individuals in this webinar probably have been doing this every day. So please pardon me for that. Anyone new who's just joined, because we find a lot of students joining these webinars, hopefully this is something new for you to think about. And if you really take a deeper dive into your legal business, you would recognize that you spend a lot of time during the matter management process. The client intake is pretty straightforward, putting their first name, last name, a correspondence address if they have one, a communication number or an email. And then, depending on the right tool sets that you have, conflict checks can be a click of a button. So that can be done pretty fast. Many legal businesses have, assistants and others who can manage these standard procedures. The matter management is really where a bit of your branding, the individual legal professional's DNA comes into play. It's your expertise, it's your money-making component or life cycle of the overall business. Because if you look at any of the practical needs of your business, as well as the compliance needs of a law society audit, it starts with the matter. So a ledger or a journal, just as a quick side story, if you look at any ledger or journal, we've discussed this in many previous webinars, if you go one step forward, all of that comes from a matter and the details and the data that you save in the context of a matter. The client ledger is very specific to a matter. So if you look at a ledger and if you have multiple matters for the same client, it is required that you document them separately in the context of the matter. If you look at fees, it's in the context of the matter, and hence your accounts receivable become that much more important. Your trust management is very important because you accept the retainer in regards to a specific matter. Because you could have multiple retainers, one for a real estate transaction, you could have a different retainer for a criminal matter, right? So if you really think strongly, having a good matter management process, as well as the right tools that you can help yourself with to improve operational efficiencies and automate things, the better you're going to be at in replicating a successful formula. Some other aspects that you probably don't necessarily think about all the time that are still necessary from an overall audit perspective or even for your own internal file process hygiene include the likes of an organizational tool or file organizational and document management tool, which comes as part of the matter management. For example, if you are to generate a retainer letter for a matter, where do you actually store that digital copy, or do you print it and put it within a manila folder? If you are sending a retainer agreement in today's modern context of, post-COVID, how are you enabling your firm to be more digital, more electronic? Are you sending that retainer letter with a simple link for payment? Are you sending a receipt with a quick link for payment? You now have to start asking these more relevant questions for today that go along with a matter management business process. From a file organizational perspective, of course, the Law Society talks about having unique file numbers so that it's easy for you to identify a file or a matter. And of course, I'm going to be using file and matter in the same context, so it's kind of the same thing. So starting with having a unique identifier for these files, moving along to the crux of the actual file or docket itself, or the matter itself, we then move into the retainer agreement or the engagement letter. Once that's signed, ensuring now that the funds that you received as part of that retainer is now transferred, first and foremost recorded in the context of this matter, and then in real life ensuring that the money is in the trust account. And then comes the aspect of your day-to-day task of docketing, dispersing, invoicing the client so that you can reflect on the work accomplished and hence legally ask for the earned business money out of that matter, which relates to your trust transfers. If there are no trust money involved in this particular matter, then of course the payments that you receive needs to also be tracked right under the umbrella or the context of this matter. And last but not the least, you would end this matter on a good note of sending your client a thank you letter, a complete statement of activity, a bill of costs, whatever that end client may need, so that they have the complete history of the work accomplished, the finances transacted, and a zero balance ledger keeping them at peace. Okay? And then providing them all the receipts because they may end up using those receipts for their own auditing purposes. And the status updating of the matter really relates to a process efficiency within your law firm to close or archive a matter once the job has been done, so that you don't always have all your matters in a single status of it being current or active, because you always want to focus your team and your strength on the current active matters and use the closed or archived matters, if you were to call them, as a means of historical data as well as data that's relevant for conflict checks and so on and so forth. Or sometimes you could use these closed matters as a very good case study or an example of a successful matter execution, so that you can simply copy the steps involved in that matter when a very similar new matter shows up at your door, right? Quickly, I'll run through this. Of course, I want to be cognizant of time. From a file management standpoint, some of the salient aspects that you probably want to keep in mind from a professional obligation as an audit perspective is ensuring, as I mentioned, the conflict check of that client, ensuring that you have a unique identifier, or making sure that separate matters are maintained for the different contexts of work done, even if it is for the same client. Finding an internal methodology or process, or use a system that gives you that flexibility of chronologically and securely managing these files, especially if they're digital. And of course, today's day and context, cloud management, storing data on the cloud, has kind of become something that we're all able to relate to. We've come to be a little bit more warm towards the concept of cloud, and we certainly appreciate and understand the risks or rewards of cloud data management. But it still is within your best interest to interview and ask the questions to the cloud providers or system providers that you work with to understand what those protocols are for managing your data on the cloud. And the last two aspects, of course, are ensuring that you have a proper step-by-step methodology, process, or software-based intake to record all of the information that we just spoke about, including the client interactions, including, let's say, a driver's license that you just scanned to validate that this is truly John Doe, for example. So all of that becomes part of that initial file management obligation, that you do store each and every piece of information. Let's assume you've done all of that. It's fantastic. You've got John Doe's information. You've actually created a file for a small claims matter, let's say, and you've also done your conflict check. And though there are several John Does, you have identified that there are no conflicts in representing him. Or even if there are conflicts, maybe you have your own valid reason for why you still want to go ahead and represent John Doe. That needs to be clearly articulated and documented within a conflict check form or a conflict check report, as it's called. Now, let's say you've done that. The next step is, of course, around an obligation as part of the service and communications. You've done the client intake, then comes the service and communication. The service obligation comes around the clear articulation of your capability as a legal firm, your responsibility as a legal firm towards that matter, your responsibility towards the client, the correspondence, the professionalism, the ability for you to respond, manage finances, etc., etc. And the communication aspect comes around the means of communication, whether it's print, digital, talking about the risks and rewards of this within a retainer letter so that you get your end client to also be warm and happy with your preferred means or channel of correspondence. Okay? And you setting those expectations, of course, for your client and the agreement that you have with the client saying, as much as you, the end client, expect me to respond within, let's say, 24 or 48 hours, I, as the legal firm, also expect you to correspond back within, let's say, the same 24, 48 hours or whatever that time may be. That way now you have a two-way street. It's your obligation and the customer's obligation documented within that document, which we call the retainer letter or the engagement letter. Simple things to keep in mind. This is a new year, so you may have an opportunity to tweak, update your retainer engagement letters to tighten the verbiage around obligations and how best you can articulate the confidence with which you're able to offer or deliver the service. Tightening, of course, financial management. For example, we've started to hear about law firms, especially the law firms who just started business, tweaking their retainer agreements to make it a little bit more concrete or straightforward to talk about fees and the rules that govern around late payment. This is a much talked aspect of a retainer or engagement letter. Do you charge the interest if a client does not make a payment within the agreed upon days of sale? Or what action do you as a legal firm take if for non-payment, for bounce checks, etc., etc.? So now is the time to start to think about these things and make them as part of the retainer engagement letter. So scope of matter, what is it about? Your responsibilities, the client's responsibilities, course of representation, very important method and frequency of communication, including invoices. So frequency of communication is also the fact where you communicate through your invoice the financial transactions that have occurred, whether you send them an invoice as soon as something occurs or a disbursement or docket has entered, or if you do it over a pre-planned set of events. Let's say, for example, an immigration matter, you may have a block fee up front, and once a certain component or trigger point has been reached, then you trigger the next block of fees to be represented in that invoice, right? So very similar to that. You determine through this retainer letter the method and frequency of communication, including the invoices. I'll run through this real quick. If you want a deeper dive, please do search Disbursements Demystified in our YouTube channel, which is a 1-hour CPD credit webinar. But of course, the aspect of disbursement, very critical to a matter, because this is where you may potentially pay money in advance to work on behalf of the client's matter. And we've spoken enough about the benefits of managing disbursements through trust and your general funds. So managing disbursements within a file or matter management, very critical, alongside with your dockets. Because the dockets and disbursements are the two critical factors or avenues through which you're able to clearly tell your client the work that has been done and the amount of money that they owe you. Now, often we've heard about the Law Society audits, and we continue to argue the fact that it's not a fear factor that you should have in your mind. One of the aspects that we're trying to communicate through these webinars is there are various different facets of your audit. Of course, how important it is for you to keep in mind the trust and how you manage trust funds, and the financial components of your audits always take precedence. There's a lot of priority provided to the financial components, especially around trust in an audit. But often we also find from talking to auditors, talking to our clients who are being audited, that there's also the subtle introduction of asking questions that lead and are sometimes even pinpointed to audit requirements regarding file management or matter management. For example, auditors may ask you, can you show me the list of retainer templates that you have, or can you show me a retainer receipt template that you received and you've signed and provided to your client as part of this matter? Can you show me proof of the client ID that you received, and how have you stored it? Can you actually show me a conflict search report? Sometimes it's expected to be in the exact template that the law societies provide you as a general guideline. And the reason for that is the data components in it are important. As long as you have the data components in it in a totally different template, I don't believe there's much of a worry, as long as you can justify that you've done all the necessary steps. So here are some of the documents that you should keep in mind with whatever system of choice that you may have. Client intake process being a prerequisite, there are a few documents that surround that, which include client ID verification documents. So please do have a way that you can scan, so you can purchase these scanners that are very cost effective now, that you can buy online on Amazon or Staples or Best Buy, Walmart. You have these wonderful digital scanners that you can have in your office, your home office, and making it easy for you to not only scan documents, but also store them digitally once scanned. So asking your customer for a scanned driver's license, storing that digitally, or if you are open for business at a later time, they do walk into your office, scanning the driver's license is faster and more recommended than just taking a photo. If it's corporations, of course, there are documents that are associated with that. Your incorporation documents, etc., could be the verification. A client intake form, whether it's your website that you use for this, or a Adobe PDF document, or a fillable Word document, whatever it may be, helps you to capture information about the client. Or you can actually simply be on the phone, open up your software or practice management, legal accounting software of choice, enter it directly into that system. Then comes the aspect of your conflict check, the conflict check report. Then comes the aspect of whether you move forward, or if you're not engaging, then auditors sometimes do ask for non-engagement letter templates. Retainer letters, so that you are doing everything. They want to make sure that you as a legal firm are covered through that document. May make some recommendations around the retainer letter. It's too simple. They always do check that you have retainer receipts, once again, to cover for yourself, so that you don't make that mistake of not sending a receipt and leaving the opportunity open for your client to come back and make an argument that a higher amount was paid, for example. And we've heard that happen before. Sometimes you may be also asked to produce invoices that you've created for your client matters to make sure that they are clear and consistent with the engagement and the retainer letter. Because we find that there have been a few complaints in the past years from the general public around the professionalism with which certain law firms conduct themselves around communication and the clarity of communication. So auditors, of course, want to make sure that that aspect of your business is protected, and it's also protecting the law societies. So clear invoicing as well as any closing statements is something that they may ask you. They would ask you all of this sometimes in the context of a follow-up audit, maybe in the first audit. So you definitely want to be prepared in this regard. But something that we encourage and advocate for is also being proactive and being that better student, if you will, of this process of providing or storing information around certain statuses in a timely manner. So for example, statement of activity is something we talk about often. The statement of accounts. Certain businesses ask for a bill of cost, and then storing all this information, sending this information to your client, but also having that stored that you have done that makes you look better and you shine better in those audits. Of course, a well-drafted closure letter allows you to bring a nice logical closure to that current or that specific matter relationship that you have. So you may have a client that has one or two open matters, may have several closed matters, but it's important that you've closed that matter. You're not closed in the relationship with the client, but you've closed the context of that particular matter to that closure letter. And sometimes as part of that closure, there could be trust funds that are moved, et cetera, right? So it's important that you're very clear about that logical closure. I probably don't want to spend too much time on this slide, though I've often used this as, we created this slide as this was a question raised by many of our clients, which is, we find sometimes auditors have asked this question to the legal professionals around certain types of documents that they use as best practices, but the legal firm uses as a means of communicating and updating their clients around the status of a matter, especially the open matters. So if you're dealing with an ongoing matter, depending on, how far along that matter is and the sensitivity of the matter, the nature of the matter, having a certain general guideline or some best practice around certain documents that you may want to share with your client, even before they ask you for it, as a means of you being very prudent or professional around how you manage their data. Right? For example, a monthly statement of invoices generated, especially if you're dealing with a corporation, having that is something that we've started to see. A lot of our clients, legal practitioners who use our platform, they do generate these monthly invoice lists, all the invoices generated with that client, and then send that to their clients. In a totally different context, you may have quarterly documents, right? Quarterly documents such as statement of activities, quarterly documents such as an aging report. So some clients want to understand the days of sale. If it's a one-off small claims matter and it's a quick and easy, fast matter, it's not ongoing, then of course they would look at the retainer agreement or the engagement letter, invoice generated, maybe it's just one invoice, and a closure letter, and the trust and general ledgers. If it's an ongoing relationship with the client, on a monthly, quarterly, semi-annually, and annually, there are opportunities for your legal firm to generate certain important documents that give the audit trail of the matter and its life cycle to your end clients. A good example of a yearly update is a statement of account, as well as, my opinion, a statement of trust and general accounts. So how often do I reach my client with an update? Of course, it's determined by the matter and the nature of the matter. But if it's slightly a prolonged client-matter relationship, then here are some examples to consider. Now, for certain silos of practice, now we're slightly stepping away from some audit requirements to a little bit more of operational tasks that are part of matter management. Now, for certain silos of practice and certain, of course, types of practice, there are the concept of court forms that you may, as a legal practitioner, be required to fill out. For example, if you're dealing with a family matter, you may have the appropriate court documents such as a Form 8A. If you're dealing with plaintiff's claim in a small claims matter, you've got your 7A. You may have various similar court documents from various silos of practice. WSIB, accident benefits, even criminal court forms. Most often here found in Ontario, in the province of Ontario, of course, is the LATB, Landlord and Tenant Board, right? Now, what's important for you to keep in mind, depending on the nature of business that you represent to your legal firm, is now a business process. I'm sorry, I'm repeating this word quite often, but it truly is that. A business process that allows you and other colleagues in your legal business to be able to make it easy, consistent, reduced errors in filling out these forms. Because often information is changed, court forms do go through certain changes, so you want to be top of your game, always using the more recent form, making it easier that even if mistakes are made, it's easier to correct. So that the court forms that you produce and generate, the information that's inside that court form is well validated. Because you don't want a situation where you have the wrong information in a court form that does not reflect well of your legal firm. And in doing so, one of the interesting aspects that come across when you're dealing with these court forms is there are many different parties and informational pieces of these parties that are captured within these court forms, right? So the court form is really looking to understand, all right, who are the two opposing parties, for example, that are related in this matter. So if you have a plaintiff's claim, they certainly want to understand the information of the defendant or the defendants. There could be multiple defendants, there could be multiple plaintiffs, right? The representatives of these individuals, so that could be yourself, maybe representing the plaintiff, or if it's a defendant's claim and you're representing the defendant, then you are the representative, and the opponent may have their own legal representation. So all those individuals or firms are parties now. Those are pieces of information that you capture in the court form. But storing this information within a matter gives you an added edge, and that makes your conflict checks that much more granular. It also makes it easy for you to do the next conflict check because you now have a detailed understanding of the relationship of a name or a person with regards to your files. So not only would you know when the next John Doe comes, or let's say you have, Sarah Connor, and let's say she was a defendant in your last John Doe matter, when the next Sarah Connor comes into your office and you do a conflict check, you now have a detailed understanding that there was another Sarah Connor that you have come across who was a defendant in a previous matter that you dealt with for John Doe. So having that level of understanding makes it a little bit more easier on you and your colleagues to do those conflict checks and make the right decisions. So additional parties facilitate faster court forms filling and an understanding of the relationship that these parties have with regards to that matter, and hence it's part of that matter management. But finding a way to group these parties and storing their information also allows you the added capability of doing a much more granular conflict check. Okay? Now, as I mentioned earlier, though there's a lot of cloud around financial management, and it's important, a good starting point of all that financial aspects comes from the matter. So if you're invoicing a client for 5 hours of work, it's the matter and the context of this matter where you're going to be entering the amount of time spent, what was it for, and how are you going to charge that 5 hours? Is it a agreed upon billable rate of $400 or $300, which is governed by the retainer or engagement letter that you have signed? That's also part of that matter management. And when that invoice is paid, let's say it's for, once again, a small claims matter, because I'm so stuck with that silo of practice, I apologize. Now you as a business, if you have, of course, the right process, the right way of categorization, and sometimes even the right tools, now you have the added power of a large law firm, especially if you're just a solo practitioner or a small law firm. Understanding the financial numbers in the context of a matter gives you some additional insight about your business. Information such as which silo of practice amongst the many practices that your firm may have the skill sets in, which area of practice do you generate the most revenue in? I'm sure these are questions that you ask yourself every day. Sometimes you don't have the right tools that can give you these answers. Sometimes you're just not in the zone to put the effort to capture this the way it is. You're always thinking about getting the next client, adding the revenue. But taking a pause, working on these different contexts, empower you to make good, not only marketing decisions, but good business decisions. Because one is to understand which area of practice is giving you the most money, but it is also important to understand which area of practice is not giving you money at all compared to the amount of marketing that you may be spending. So even if it's not bringing in revenue, it should not be costing you money and going in negative. So these are two important aspects that we would love for you to keep in mind as you practice and run your business this year, is to always be looking at the model of, typically they talk about the low touch point, high value revenue, or low cost, high value revenue, rather than a high cost, low value revenue. So whether it's legal business or non-legal businesses, these are two important terms that are often spoken about when it comes to managing your business revenue. And how do you know which areas of practice are your low cost, high value? You would do so by running these analytics, by understanding the numbers and the information behind these numbers in the context of your matter management. Ledgers and journals are one thing, which are important nevertheless from an audit perspective, also from a compliance standpoint. But understanding information around revenue generators and the high cost, low value revenue bringers makes it easier on you as a business owner to run your business. So you could have pieces of information such as timelines of a matter. How long does it take before you get to that invoicing stage? So that's a very important question. In a small claims matter, maybe it takes less than a day or 2 days. In a criminal matter, it might take you several months or sometimes weeks before you get to that invoicing stage. In a real estate matter, it's rather straightforward and well defined. If it's an immigration matter, it could be different. So compare and contrast, and then make good decisions on which areas of practice are best suited given today's nature of running businesses. If the courts are not opened, or if there's reduced amount of footprint in the court, and if people are still figuring it out, then do you need to work with matters that need that time? If you don't have that court time, is that leading to you not being able to move to the next step, and hence kind of hurts your revenue generating process? In which case, either educate yourself or make yourself familiar or work with partners in a different style of practice that does not have maybe those occupational hazards given today's COVID situation, right? So managing matters is one thing, but having a process and a very clear-cut process to give you the desired data information is a totally different thing. And hopefully in 2021, we're all working towards getting there, so that we're always smart about running businesses. Because it takes a lot of courage to run a business, and you should certainly equip yourself with the right tools, skill sets, strategies, so that we feel confident, nice about ourselves in running this business and being profitable, so that really sets as a good example for others who want to follow suit, and for ourselves too, and everyone who's running a business to be happy and successful in doing that. We've advocated often, of course, this around mobile docketing. There are two components to having access to information on your mobile in a mobile-friendly manner. Of course, pre-COVID, this was a very important, one of the important aspects of mobile friendliness was the ability for you to not miss out on any information, especially if you're on the go. If you're at a courthouse and you have some load time, you could use a mobile phone instead of opening up a laptop to enter information. But now, as we find ourselves to be more at home, working out of our home office, where mobile comes into play is the natural progression of human beings moving away in general from using laptops to using mobile devices. We often start off our day with picking up on a mobile phone, checking our messages. Of course, it's interesting times now, people talking about WhatsApp or Signal or other types of these communication channels. So we all start our first day with using a mobile phone rather than opening up a laptop. And that seems to be the general norm. So mobile docketing becomes, from that perspective, a bit of relevance, though not as relevant as when we used to be more mobile to begin with. But certain interesting components as part of the mobile aspect comes into features that you should keep in mind, or processes that you should keep in mind around docketing telephone conversations. That's a definite must. So if you don't have the capability to do mobile docketing, it's not the end of the world, but having it helps in some of these areas. So if you've made a conversation with a client and you can make it easier for that to be added to the overall docket in a matter, why not? these are questions that you may want to ask yourself as you explore the right tools to help you in your business. Very similar, we find email conversations becoming a big part, especially in this post-COVID situation where there's a lot of electronic communication and correspondence with our clients and other parties involved. And having information on the go is another aspect, which is a great nice to have, which is slowly turning into a must-have, right? So it's easier for you to access information on a mobile device, still have the same power in the palm of your hand rather than having to go into a laptop. I'm going to try and skip all of that. Of course, with another less than about 10 minutes left, I'll probably wrap with this and maybe take the next 5 to 6 minutes to show you quickly, using uLaw as an example, of what you can expect with the legal accounting and practice management software if you are looking for one. And you should certainly do your own homework with the different tools that are out there and the ones that best suit you and your style. But typically, a legal accounting and practice management software was purpose-built, or in this particular terminology itself, you can figure out that it was purpose-built for legal business. A practice management software can be for various different types of practices. It could be for legal business, it could be for dentists, it could be for other areas of practices as well, if you need. But a legal practice management software or legal accounting software combines the data aspects of entering information, but also relaying the amount of legal accounting that needs to be done to crunch the numbers to provide the ledgers and journals that you do need to submit, especially when you have to reconcile and generate that on a monthly basis, right? So something to think about is the cost of ownership. Whatever tool that you consider, these are things to consider as a legal practitioner. What's your current cost of ownership, whether you do it manually or using another tool? What's the amount of efficiencies that you can bring? So even if you're using a current tool now, it doesn't have to be where you have to change that tool. What you could think about in the new year is, can I get more training? Can I understand how I can use this platform better to improve on my efficiencies and my use of the software to derive more value out of that software? Right? So often customers buy a software initially, for some quick wins, and then kind of stay around those quick win features all the time, where they can slowly start to expand in their understanding and appreciation of the various other features that have been built to help build those efficiencies higher, which is becoming a major game changer for legal practitioners today. Of course, you want to be very cognizant of a software or a system that can tread you on the right path for compliance. Certain softwares can give you legal compliance at a click of a button. Certain softwares provide you with the right tools so that you can generate those out of that system. Some systems you need to recognize will never be able to provide you that compliance document or need a lot of effort to get that out of you. You want to stay away from those manual processes or those softwares where you tend to spend more time to generate this output. Practice anywhere, of course, in today's day and context is slightly different, but let's all hope that post April, May, June, once the vaccination is on track, that we're going back to maybe a renewed world, but with some instances of our previous life, which is to be a little more free and get out of our homes, crying out loud, and hence giving this context of practice anywhere a little bit more of context. Because right now we're just in one place, in our homes, unless you're out in Canada. Um, uLawPractice.com, it's almost been 11 years now, a Canadian company based out of Ottawa. We serve only and only legal practitioners. What we offer is a growing legal accounting and practice management software. Please do visit our website. We do offer a no obligation 30-day trial for you to have a better appreciation of the platform, understanding of the tools required to run your software. With another 5-minute, kind of almost 5 to 4 minutes remaining in this webinar, I encourage you to use the chat window to ask any questions that you may have. Once again, the title for today's webinar is Law Office Matter Management. It's been accredited for 1 hour of professionalism CPD credits, and the past 55 minutes were kind of really typical monologue from my end. It's been around the importance of matter management, how it pretty much covers various aspects of your business, legal business, the importance of having a well-defined process, strategy, and methodology to capture information, to store information, and reflect the information in various different compliance and practical documents that you need as part of that matter management, right from client intake to the retainer agreements, all the way to a closure letter. And if you look at uLawPractice, we make it, of course, easier for you to enter a client, which is that initial prerequisite of a client intake, where you have the ability to capture first name, last name, date of birth, which can relate to certain court form information, the correspondence address, phone numbers, and even email. Once you've created that client, of course, it's important that you've done a conflict check, making it easier for you to generate and get an understanding of any potential conflicts in representing Jonathan Fong. And let's assume there are no conflicts. We move forward with the matter itself, where you now have an example of the ability for you to capture retainers, the ability for you to docket, enter disbursement. And if you have more questions around this, please do reach out to us, and we'll be more than happy to do a one-on-one session. But here's a good example of a conflict search report that tells you there's a few Jonathans for first name conflicts, a few Jonathan in the last name conflicts, and there are a few names that sound like it. And it date and timestamps it so that you can be very confident in producing this as the example that you'd used or the proof that you'd used to move forward with generating the matter, ensuring that there was no conflict. And throughout the product, one thing that you would see consistent is, true to the nature of the business, having compliance built right in. Depending on your jurisdiction, these documents would change, of course, from province to province. But if you really look at the whole process of client intake, you pretty much have possibly all of the compliance documents needed. I believe I'm in the context of an Ontario legal practitioner, with examples of samples of retained letters as well, which can also be generated in PDF and in Word so that you can easily tweak that information. Right from client ID verification up to a closing letter, as you walk through the different life cycle stages of this matter, you have information being stored behind the scene and documents and reports being available for you to generate at a click of a button. So this is where you say, I got the driver's license, and you can store that scanned driver's license right within our Documents tab as a digital repository as well. We also give you the flexibility to capture your retainers, your disbursements, and in the context of parties involved, we allow you to capture the various different parties and the different roles and party types that there are in this context of a matter, because that makes conflict checks easier, but also gives us the ability as a software to generate these court forms. So if I'm generating a plaintiff's claim, and let me choose an appropriate matter. So let me choose a small claims matter. Of course, the parties in this vary. You've got Adam Brown as the defendant, Stefan as his representative. You have multiple defendant situation. In fact, you have multiple plaintiffs too. And in generating the court forms for such a matter, all that information is utilized to pre-populate these court forms in the right columns and in the right structure that it's expected. And here is an example of a retainer letter with all the information pre-populated in the context of this matter, making it easier for you to, of course, tweak this information. And here's a sample example of a small claims court form in the province of Ontario. With the address of the court, the plaintiff information, which is Jonathan Form, his address. Again, you can expand on this as you type into the Word document. You got information about the representative of Jonathan. You got the other defendants, the Adam Browns of the world, who were added as a defendant party type. Their information automatically being captured from our contacts database, because it's a prerequisite that you store their information once in the database so that you can repurpose it again and again. So where do I find Adam Brown? I guess that's the question, is in our contacts database, because our contacts is a repository of not just client information, but all the different types of parties and contact of people and companies that you deal with in your legal business. Right? So you can make it easier for you to group these contacts in the context in which you've stored them. Whatever you have in that matter gets automatically populated here. So I know I've just passed my cutoff of 4 minutes. So I will then complete today's webinar, once again reiterating the need for you to redefine better, efficient manners, keeping in mind how fast you can finish a client matter, how fast you can generate revenue, the whole concept of low-touch, high-value clients, being able to derive information from an analytics standpoint of which are the different areas that are generating the top revenue for you overall. Of course, this is a new year and we don't have much of information, but as you add the information, this would, of course, automatically change. And also having a better plan for storing and reporting this information in the most compliant and regulated manner, making it easier. So you can see overall in the last 2 years, you've got family law being almost 20% of your overall revenue. We've got the next big thing as contract review and drafting, with POA and real estate as the top 5 areas of practice that's bringing this law firm revenue. All of this comes from the aspect of you tagging at the time of intaking that matter, the type of matter it is. It takes the total invoice cost. So you can see we've made $339 in this matter. That's directly related to the small claims bucket of revenue. Okay. And if there's any additional questions that you may have with regards to how we do this, we'll be more than happy to demonstrate it to you. Biggest takeaway is having a process and having a well-planned methodology to manage your matters for high efficiency, compliance, and an error-free experience for your legal firm. So with that, I will wrap up today's CPD webinar. I thank everyone who joined me for this webinar. Please do use the title Law Office Matter Management, enter it into your respective law society portals. And as always, stay safe, stay healthy, stay positive, be motivated. And I'm sure as we'll come out of this stronger as a unified team of individuals. Thank you. Look forward to seeing you at our next webinar next Friday at 2 p.m.